Okay, picture this. A lawyer helps someone out for free. A simple act of generosity. But what if that good deed actually landed them a tax bill? Sounds kind of crazy, right? Well, it's not a hypothetical. It's a real puzzle that the European Union's top court is trying to solve. And it all boils down to one question. Can you actually be taxed for doing something for free?
I mean, that's the big question here, isn't it? And you'd think the answer would be simple. No money changes hands, so no tax. Easy. But as one Bulgarian lawyer found out, the world of VAT, value-added tax, is full of surprises. And this particular twist has implications that ripple out across the whole EU.
All right, so let's dive in. Our story kicks off in Bulgaria. And it really has this classic feel to it. A lawyer steps up to help someone who just can't afford the legal fees. It's what's called pro bono work, a real act of professional generosity. But this one good deed, it's about to get really, really complicated. So here's the play-by-play. A lawyer takes on a case pro bono for a client who's really struggling financially. So far, so good, right? A generous move. Then they win the case. Awesome outcome. That's when the local law in Bulgaria steps in. The court orders the losing party to pay the lawyer a legally required minimum fee. Still seems okay. But here's the kicker. The lawyer is VAT registered, so they try to add that to that fee. And the losing party basically says, whoa, hold on. How can you tax a service that was provided for free? And just like that, we've got a legal standoff.
And you're probably wondering what huge sum of money sparked this massive international legal debate. Well, get this. It was 400 Bulgarian levas. That's about 205 euros. The actual tax amount in question was something like 40 euros. I mean, it's a tiny amount of money, but the principle behind it is so huge that it's gone all the way up to the EU's highest court, the Court of Justice.
Okay, so to really crack this case, we have to get our heads around one single crucial legal term. The entire thing hinges on this one word, consideration. You can think of it as the gatekeeper that decides what gets taxed and what doesn't. So in the world of VAT, consideration is basically what you get in return for a service. The rules seem straightforward. No consideration, no VAT. So the whole argument here boils down to this one question. Does that €205 fee, which was paid by a third party because a court ordered them to, does that count as consideration for the service the lawyer gave their client for free? And this is where you can see the two sides of the argument so clearly. From the client's perspective, it's simple. The lawyer said, don't worry about it, this is free. There was no invoice, no payment agreement between them. But from a tax law perspective, you have to look at the economic reality of the situation. A service was provided, and a payment was made for that service. So the big question is, does it really matter that the money came from a third party just because the law made them pay it? All right, so this is where Advocate General Juliane Kokott enters the picture. Now, her job is to give an expert legal opinion to the Court of Justice to help them figure this all out. And her analysis, well, it cuts right to the very core of what that is even supposed to be. And this quote from her opinion is just everything. She says, that is a tax on consumption, not on contracts. What she's arguing is that we're getting bogged down by focusing on the agreement between the lawyer and the client. That, she says, isn't a tax on paperwork or contracts. It's a tax on the consumption of a service. So her whole point is this. Let's ask the simple questions. Was a service consumed? Yes, absolutely. The client got legal help. Was a payment made for that service? Yes, the lawyer got paid that fee. So from a VAT perspective, it doesn't matter who paid. The client, the losing party, whoever. The economic reality is that the loop was closed, a service was used, and it was paid for. Now, to make her argument stick, Kokott had to explain why other famous cases don't really fit here. For example, there's the Tolsma case, where a street musician's tips weren't taxed because they were voluntary donations out of sympathy. Then there's the Bashtova case, where prize money for a horse race wasn't taxed because it was a reward for an outcome, not a payment for a service. But this Bulgarian case, it's totally different. The payment isn't voluntary, and it's not a prize. It's a legal requirement that's directly linked to the lawyer's actual work. And that brings us to her big conclusion. It's all about substance over form. The key thing here is that the law itself creates the direct link between the service provided and the payment received. That legal obligation is what makes it consideration. It doesn't matter who writes the check. So you might be thinking, why do we care so much about one little €40 tax problem? Well, here's why. If the Court of Justice ends up agreeing with this opinion, the ripple effects are going to be huge. We're talking about an impact on lawyers, nonprofits, and even the courts themselves, all across the EU. Yeah, the implications here are pretty significant. First off, it kind of shatters the simple idea that pro bono automatically means that free. Turns out, if there's any kind of legal requirement for payment, even from a third party, tax could be on the table. This means law firms are going to have to watch out for this, and courts might even need to change how they award costs. But bigger picture, it reinforces a fundamental EU tax principle. It's the economic substance that matters, not the form. It's about making sure that the same service gets taxed the same way, no matter the weird and wonderful ways it gets paid for. Now, it's super important to remember, what we've been talking about is the Advocate General's opinion. It's incredibly influential, for sure, but it's not the final word. It's not the legally binding judgment. The actual judges of the Court of Justice are now going to think it over and issue their own ruling. And you can bet that tax pros all over Europe will be watching very, very closely to see what happens. And that kind of leaves us with one last big thought to chew on. If the guiding principle is that tax has to follow the economic reality, well, that makes you look at our modern world a little differently, doesn't it? I mean, we live in an economy that's just packed with free apps and free services, where we often pay with our data instead of our money. It makes you wonder, where else might free not actually be free in the eyes of the tax authorities?